the one from United States was actually in Spanish and not in English, so maybe
Okay.
it makes you happy.
at least
I swear it was. That's what the paper wrote, at least.
Okay. I'm now happier now. It's good point, Leonardo. So thank you again for the invitation. It's always a pleasure to participate in these lectures, and also I would like to congratulate Professor Pasquale and all his team at the University of Pisa for the hard work that they are doing in promoting the European integration process through the Jean Monnet action. So my topic today is the relations between the EU and the United States, the trade relations and investment relations between the European Union and the United States. So as you may imagine, this is a complex topic, especially under the current circumstances in which, as you know, there is some sort of a trade war between these two regions. The United States has threatened to impose tariffs against EU products, and the EU has announced that they will retaliate, and they will also impose tariffs to the US products. So I will try to do my best, although the current context is perhaps not the best to explain how a proper trade and investment relations between the US and the European Union should be conducted. Anyways, let's try to explain the legal issues, although I will also refer to some political facts and figures. First of all, I have some data, some numbers to reflect on this assertion. To what extent? And I have set. I think that there are 6 or 7 slides in English, and then I will move on to the slides in Italian. Don't worry. I promise that the majority of the slides of my presentation are in Italian. But this is a very important assertion because to which extent the transatlantic trade relationship is important. It is important or not? Some would say that it is, and I have here some figures that try to demonstrate that it is a very important relationship. For instance, look at these numbers. 1.6 trillion euros in 2023. That's the amount of euros exchange in goods and services between the European Union and its member states and the United States. So if you see those figures, you may conclude that it's quite an important relationship. Each and every day, 4.4 billion euros worth of goods and services cross the Atlantic between the two regions. So it seems quite an important relationship. Let's focus on the trade in goods. And in this aspect, I have to highlight that the EU has a surplus regarding the United States, 157 million euros of surplus, trade surplus in the trading in goods. So we get more than, receive more than that we export to the US with regards goods. That's quite an important achievement. And as you see, this surplus is sustained through the years. So it's not a 1 year that we have surplus. No, in the last 3 years we have had this similar surplus between the US and the EU in what matters goods. However, regarding services, the trade in services, in that respect, we have a deficit. The US gets more money regarding the commercial relation vis-a-vis services with the EU. But again, the numbers are quite similar. And if you see, it's a quite balanced relationship at the end of the day. With regards to investments, direct or indirect investments, the participation in companies, so on, shares, direct shareholders or indirect shareholders, there is quite a important amount of money involved in this relationship, 5.3 trillion euros worth of investment. And these are data from 2022. So if we analyze this data and we ask the question that I posed previously, we could conclude that regarding having taken into consideration all these data, there should be quite an important relationship between the EU and the United States. These are the numbers regarding investment. As you see, there is quite a balanced relationship between both regions. Let's focus first on the trade relations. I have two major parts of my presentation. First, I will deal with trade and then with investment, but I want to tackle these two issues separately. As regards trade, as you may know, the main international organization dealing with trade is the World Trade Organization, based in Geneva. It is an organization which majority of states are parties to it, and this organization, within the context of this organization, several international agreements have been concluded, and those agreements regulate several trade issues. This is a list of some of the agreements, the most important agreements concluded within the framework of the World Trade Organization. As you see, it is quite a complex system of agreements, trade, sanitary and phytosanitary measures, agriculture, subsidies. There are quite a lot of different issues, but they are all trade related. And that organization is responsible of making those agreements, implementing those agreements. And in case that there is a dispute between two states parties to that organization, the organization will have its own dispute settle mechanism, and that mechanism will settle the dispute between the member states. This is precisely what I want to stress now. That organization has its own dispute settlement mechanism, and any dispute arising from these agreements, the agreements of the WTO, is settled within that organization and using that dispute settlement mechanism. Is a dispute settlement mechanism based on arbitration. As you may have studied, international law has basically diplomatic measures in order to settle dispute, and also it provides with judicial measures, and within those judicial measures, arbitration is one of the most important. Also the permanent jurisdiction, but in this case we're talking about arbitration. So this is a slide which shows you the number of cases of disputes raised within the WTO, and also which agreements are invoked in those disputes. As you may see, the most important agreement is the GATT of 1994, General Agreement of Trade and Tariffs, concluded in 1994. But as you see, there are also disputes regarding anti-dumping measures, subsidies, agriculture, etc. There are quite a lot of agreements within the WTO regime, and if a state considers that another state is breaching one of those agreements, it can bring a dispute against that state within that framework, within that legal framework. As you see, this provides legal certainty. It provides an institutional framework in order to settle international disputes. This is one of the main achievements of the WTO, to create an institutional framework in order to settle disputes regarding trade. The procedure works basically, as you see now. First, if a state considers that another member state of the WTO is breaching one of the agreements, what that state does is to initiate a consultation procedure with the other state. The result of that consultation could be a settlement between both states, but if there is no settlement, then the arbitration begins. The WTO establishes a panel, and if the panel issues, of course, a decision, that decision can be agreed by both parties. And then if the decision is agreed, then, of course, the dispute finishes. But one of the most important, most interesting things of this proceedings is that the party that loses on first instance can bring an appeal against the decision of the panel. And in that case, an appellate body, an appellate arbitral body will review the decision and will issue another decision, which could be different from the initial decision issued by the panel. So there is a possibility in international law, you know, that the decisions of the international tribunals are final, cannot be subject to appeal. But in this case, there is an appeal mechanism. There are also other cases of appeal, for instance, the European Court of Justice, but there are very few international tribunals that allow an appeal. And in this case, you have this appeal in working. If the procedures finish with favorable to the claimant, to the complainant, as you see, then both states initiate another proceedings, implementation proceedings, in which the discussion is about reparations, which reparations the defendant state must give to the complainant in order to settle the case. Because, of course, in this case, as in any case regarding international law, international responsibility is discussed. As you know, the result, the consequences of international responsibility, if declared by international tribunal, is compensation, reparation. Which measures of reparation compensation must be adopted by the state that has lost the case. And in this case, compensation could be one of the measures, but perhaps sometimes it's not enough. Perhaps sometimes the state that has lost the case has to remove some measures that are contrary to the WTO law. So, as you see, this is how the system works, how the dispute settlement within the WTO works. And I would like to highlight the appellate mechanism, because as we will see in a few minutes, we have a problem regarding this appellate mechanism nowadays. And this problem is creating a lot of concerns within the WTO member states. These are some numbers regarding the trade disputes. And as you see, the most important part here is the bottom part of the slide, in which, as you see, the majority of the cases that go to the panel are subject to an appeal. So that means that when a state loses the case, it usually, well, not always, but the majority of the cases, they appeal. They go to that appellate body in order to have the case reviewed. Which are the states that are frequently using the WTO dispute settlement mechanism? Well, the US and Europe and the European Union. Those are the numbers in which, as you can see, of course, Japan, China, India, other states are either complainants or defendants, but the top two are the US and the European Union. And as you see, there are a lot of complaints raised by both of them, and in some cases, those complaints are against each other. Not all of these numbers refer to complaints between the United States and the European Union, but there are quite a lot of disputes between these two regions. Perhaps the most important one is this the dispute between the US and the European Union regarding state aids between Airbus and Boeing. This dispute it has been a long-standing dispute. It was initiated quite a lot of years ago, and it finished in 2021. Actually, there were two different disputes. One initiated by the US against Europe because the US thought that Europe was giving state aids to Airbus, and there was another dispute, in this case, a dispute initiated by the EU against the US because the EU argued that the US was also granting state aids to Boeing. As I said, these disputes were subject to all the proceedings, panel, appeal, implementation, and at the end of the day, in 2021, both states decided to settle the dispute because what they realized is that a Chinese company was getting a lot of advantages from this dispute. It was gaining a lot of market share from this dispute, and as they saw that the threat of a Chinese company gaining a lot of market from these two major companies, the US and the EU decided to settle and to concentrate on keeping those two companies as the top leading companies in the market, in the industry. But as you see, this is a good example on how sometimes states may settle a dispute by having a third state trying to interfere. In this case, the interference was benefiting from a dispute in order to gain market share in this industry. The dispute was settled, and of course, at the end of the day, what the US and the EU obtained was the consolidation of the status quo. Of course, it can be said that both regions were granting to a certain extent state aids to both companies. In 2018, there was a big trend regarding the crisis of the appellate body. As you may recall, I insisted that the appellate mechanism of the WTO was a very important trend, was a very important feature, and now I want to focus on this because in 2018, first Trump administration, I might recall, we witnessed the crisis of the appellate body. Why crisis of the appellate body? Well, in that moment, the members, the arbitrators in charge of settling disputes in that body had to be appointed. They had to be appointed by consensus, and the US objected the US considered that this mechanism was not working properly and decided not to appoint anyone and to block the appointments proposed by other states. So what was the consequence of this? If a decision has to be taken by consensus, that means, as you may know, this consensus is usual voting procedure in international law, which means that the decision is taken when there is no objection. In this case, the US objected, and that had the consequence of blocking the designation of the members of the appellate body. So since then, states cannot use the appeal mechanism in the WTO. The US has actually blocked the system. It's a political decision that was taken by the first Trump administration, but has subsequently been applied by subsequent US governments. So you may, if we go back to the slide in which the procedure was described, at the moment there is no possibility to appeal, to use the appeal. And as you may recall, the majority of the cases were subject to appeal. So that's why we are talking here about a crisis, an important crisis within the system. And what are the consequences of this crisis? Well, for instance, this is a recent example. Sorry, it's an example in Spanish because it involves two states, two Spanish-speaking states. But in this case, it was a complaint issued by Costa Rica against Panama because Costa Rica thought that Panama was taking illegal measures contrary to WTO law. The panel report confirmed this, said that Panama had breached WTO law. And what was the reaction of Panama? Did Panama decided to comply with WTO law? Did Panama decided to make compensation, reparation? No. What Panama did was to announce that it was going to bring a case before the appellate mechanism. In practice, what does this mean? In practice, this means that the case will be blocked because Panama has the right to appeal the case, but there is no appeal mechanism. So the case is blocked. And this is just one example. There are other cases that have run the similar route. This is why we can argue that there is a very important crisis within the WTO system, because in some cases, the states that lose the case in the first instance, decide to appeal, knowing that there won't be an appeal mechanism. So that means they can continue to adopt the measures that the panel has declared contrary to WTO law. As you see, this is a very complex situation, and for this particular reason, in order to bring some new light to this situation, and of course, in order to offer another possibilities to the WTO member states, what the European Union did a few years ago in 2020 was to create an alternative appeal mechanism. What the EU and Canada, it was a proposal shared by EU and Canada, did in 2020 was to celebrate, to conclude an international agreement in which, or through which, when two states were running a dispute before the WTO and the dispute was subject to appeal, that agreement allows to create an appeal mechanism outside the WTO system, which will decide the case. As you see, it's a very ad hoc solution. It grants some relief to those states willing to continue to use this system, but in order to be part of this appeal mechanism, of course, you have to join. You have to sign this agreement, and not all the WTO member states have signed this special agreement providing for an appeal mechanism. So, as you see, there is a big problem regarding the appeal mechanism. The EU tried to provide some solution, ad hoc solution to this problem, but the fact is that not all WTO member states are parties to this agreement. So in some cases, states will be entitled to appeal a decision of the panel. In other cases, it won't be possible to raise this appeal. Since the current administration, the U.S. administration has very strong feelings against this appeal mechanism, one can hardly see this problem settle in the next 4 years. So during this next term, the only possibilities to raise an appeal within the WTO system will be for states parties to this agreement, or if they're not parties to it, they also can join the agreement. And in that case, if they join, they can they are entitled to bring appeals within the WTO. But as you see, this organization has a big problem regarding dispute settlement, and it's a problem that has been created by the US. And let's be frank, it's not only the US, there are other states which also have interests in changing the system currently in place. The EU, by the way, has tried to maintain the current system and has provided with mechanisms to, as you see, this special agreement provides the appellate facility, but as I already said, it's a different agreement. So all member states of the WTO are not parties to this agreement, and the problem still persists. Bottom line, there is a very complex relationship between the US and the European Union, and regarding trade. And when we are talking about a complex relationship, we must also take into consideration that this relationship it does not depend on which political party is running the U.S. administration. We have had, for sure, better relations with the Democrats in the past, but sometimes policies continue in the U.S. Either they are running by the Democrats or the Republicans. For instance, this is a good example on how policies continue and make this relation complex. Think about all the technological companies. This slide shows you the fines that have been issued by the European Commission regarding the General Data Protection Regulation, infringements of the General Data Protection Regulation. And as you see by the dates, these infringements were happened during the Biden administration. So it doesn't matter which political party is running the show in Washington. There is a problem in certain areas of the trade relations. We have a problem with the US, and of course these companies when they operate in Europe, they have to comply with EU law, and EU law is in different areas very demanding. And in this case, data protection, it is very demanding. And when these companies do not comply with EU law, as you may have studied, the European Commission may raise infringement proceedings. And at the end of those proceedings, the Commission, if the Commission considers that there has been a breach of EU law, the Commission can conclude the proceedings with a fine to the company. And these are several examples of fines against the technological companies from the US, Meta, Google, and Amazon. But of course, you have different examples elsewhere. You can find examples in Google, but these are perhaps the most interesting ones. So we have a problem regarding trade, independently of which administration is in Washington. This is perhaps one of the latest fines that the Commission put on Apple. In this case, it was almost 2 billion euros for anti-steering clauses imposed on music streaming broadcasters. And this is a fine imposed against Apple, the Apple App Store. Basically, what Apple was doing is to restrict customers. They were not allowing customers to download all the music from the streaming apps, only those streaming apps that the App Store was entitled to put. And of course, as you see at the bottom, the bottom line is that you pay higher prices and you have limited choice. You have a lot of music streaming apps, but the Apple App Store won't allow you to download all the music from all those streaming apps. Only that music that is included within the parameters of that the Apple wants. And that means higher prices, limited choice. That is a situation contrary to EU law. It's a situation which the Commission investigated, and at the end of the day decided to impose that fine against Apple. So, as you see, there are problems regarding the trade relationships, but it's interesting to see that when we try to see which are the trading partners or the countries with which the US and the European Union have concluded trade agreements with, we see that there are obviously there is a common interest. On the left side, you have the agreements concluded by the EU, the trade and investment agreements concluded by the EU with Canada, Vietnam, Singapore, Japan, Mexico. That means North America and the Pacific. And of the right-hand side of the slide, you have the agreements concluded by the US. Again, Mexico, Canada, and then the Pacific. So it is a complex relationship, but at the same time, we see that there are common interests between these two regions. They have not only a very close relationship between them, but they have the same partners. This is quite interesting. And both regions started negotiations to conclude a transatlantic trade and investment partnership in 2013. It was a very important moment, because in that date, both the EU and the United States decided that it was the time had arrived to conclude a big trade agreement, with including investment provisions, and both parties negotiated for almost 3 years. 15 negotiating rounds took place between both parties, but at the end of the day, in 2016, negotiations stalled and were suspended. Of course, you may think that 2016 coincides with the first Trump administration, and in that moment, President Trump decided that this agreement was no longer a priority. The agreement was under negotiation, but as you may recall from your lessons of international law, two states can negotiate an agreement, or in this case, a state and international organization can negotiate an international agreement, but there is no obligation to conclude that negotiation. Both parties can decide to drop out, to opt out from a negotiation if they see that there is no interest in continuing with that process. And this is particularly what happened in this case. I said that it is in part because of the first Trump administration, but also the agreement had problems in Europe. A lot of social groups, part of civil society in Europe did not share the objectives of the agreement, and there were protests and demonstrations throughout Europe. And it is not because President Trump did not want the agreement to continue. It was also because this agreement found a lot of opposition within the European civil society. So both parties decided that it was better to stop negotiations and do not continue with negotiations. The current state of affairs is that at this moment we have no agreement between the parties, and there is no interest of continue the negotiations between both parties. So the only legal regime that we have is the WTO, the general regime. The disagreement was negotiated in order to establish a special relationship between both parties within, of course, the WTO system. But since there is no special relationship between both parties, we have to refer to the WTO system. And as you already know, the WTO system has a big problem when a dispute raises between two states, because if that dispute raises, there is no possibility of appeal. So this is the current state of affairs, and this map is quite interesting because it shows you the agreements currently concluded by the EU, and the US is one of the, if you see the Americas, the US is one of the few states in which Europe has no agreement in force. Cuba, Venezuela, Bolivia, and the US. It is quite telling that, but it is what it is. I mean, the European Union cannot force the US to negotiate or to conclude an international trade agreement. Fortunately, we have the WTO agreements, which set a general framework in order to conduct trade and business relationship. But as you see, the EU has made an effort to conclude special trade agreements with states spread throughout vast parts of the world. In the case of America, it has made an important effort to conclude agreements with all states, but the US is the exception. So there is a complex relationship, and some thought that that relationship would change when Biden administration began a few years ago. Of course, the first Trump administration blocked some of the reforms and the negotiations that were taking place between both parties. And when President Biden took over, some thought that that change would have a positive reaction in the U.S. trade relationships. However, when we talk about trade and investment, we must consider that there are also other issues involved outside trade that might influence the relationships between the US and Europe. For instance, this is a very important issue, Ukraine, and to what extent the situation of Ukraine has influenced the trade and investment relationships between the US and the European Union. I think it's a fair question. It's necessary to address that issue. We cannot study the trade and investment issues without having in mind another set of political questions that are part of the current developments in international law. I think that when we address the relationships between the US and the European Union, we should also consider from Europe. We should also consider first if the measures that the US is proposing are legal, are in accordance with international law, and what are the consequences, the geopolitical consequences for Europe of those measures. I think this is always very important. We must examine any set of measures, for instance, with regard to Ukraine, having in mind these issues. We cannot, and I speak now from the European perspective, of course, we cannot act as hooligans or supporters of the US in each and every business that they undertake throughout the world. Of course, we can be allies, but before taking any decision regarding whether we are going to help or not, these two parameters should be considered, whether the measures are legal and also which are the consequences for Europe for any measure. And I think that these two requirements should have been pondered when Europe decided to support the US enterprise in Ukraine. And these two parameters should have been pondered a few years ago, for instance, when the European Union, when the European states decided to support the NATO bombings in Serbia, for instance, which were illegal, were contrary to international law. And there are also cases before the European Court of Human Rights in which, as you may know, several European states were respondents in these cases. The court did not consider those cases admissible because it found that the responsibility, if it existed responsibility, the responsibility was in NATO, not in the European states. NATO was controlling the operation, and of course, since NATO was not party to the European Convention on Human Rights, the court found that the cases brought against the European states were not admissible. But this shows you how you want to relate with the US. You always have to to take into consideration if the measures that are going to be implemented are legal or not, because if they're not, they can have consequences in international law. Another example of this would be the invasion of Iraq in 2003, in which, again, the US acted contrary to the UN Security Council resolutions, and some European states decided to support the US in that case. This is a picture of those states, basically the UK and Spain, which decided it were the two main supporters, initial supporters of the US, although at the end of the day, a lot of states joined. And it's interesting that in this picture, the three guys sitting at the right, after that picture, they were, I mean, they lost power. The only one that survived, politically survived, was Durão Barroso, who became president of the European Commission. It's a paradox. This picture has always been shown as showing President Blair, President George W. Bush, and President Aznar from Spain, but there is a fourth man in the picture, President Durão Barroso, who is the only one survivor, at least from the political perspective. It is a good indication. It is a good indication that when you do not comply with international law, and I think it's a good indication for democracies. When you do not comply with international law, there are consequences. You have to be elected or re-elected, and people can decide not to vote for you if you do not comply with international law. I think it's quite a good example of the importance of complying with international law for states and for governments. Another case that I want to highlight is the Kosovo case, in which, again, the US decided to recognize Kosovo as a state. That decision was a very important decision because, of course, Serbia thought that Kosovo had to be part of its territory, that the separation of Kosovo was contrary to the principle of territorial integrity, and indeed it was contrary to territorial integrity, but a lot of European states decided to join the US, and they recognized Kosovo as a state, again, without pondering if that recognition was legal, or may I rephrase my assertion, if there were enough reasons to recognize Kosovo as a state, and second, without pondering what were the legal consequences, the geopolitical consequences of that recognition. Of course, after that recognition, Russia decided that if the Kosovo situation had been recognized as legal, perhaps certain Russian minorities living in other countries could claim a right of self-determination, and maybe part of the consequences of the situation of Ukraine right now can be traced back to the Kosovo independence. In that case, I think that the Russian authorities saw clearly that international law was being applied on an ad hoc basis by the US and the European Union member states, and Russia decided, well, okay, if these guys are not applying international or are applying international law on an ad hoc basis, why we cannot apply that also on an ad hoc basis? And I think that thought has something to do with what has happened in Ukraine over the past years. Again, the situation is a more recent example, the situation in the Gaza Strip with regards to Israel. some European states have decided to support Israel, not only political support, but by selling arms, weapons to the Israeli government, and following the path of the US. And you also have to think if this is the best way forward, because sometimes, of course, you're free to sell weapons to any government if you decide to do so, and if that operation is legal. But you might consider what are the legal consequences and the political consequences of doing so in this particular case. For instance, Germany now has a complaint by Nicaragua against the International Court of Justice, and in that case, Nicaragua argues that the German state is breaching several international treaties through which, in particular, the Genocide Convention, by helping Israel to breach that convention against the Palestine people. So, if you see, sometimes as a state, as a government, you may take a decision, you can follow, and you can help the US, but you can only do that after having pondered what are the legal consequences and the geopolitical consequences of doing so. By the way, this guy in the picture is no longer running the office in Germany, so it has taking certain measures can have political consequences in the government-wise. Again, this is another example, and this example refers to Spain. A few days before leaving office, President Trump decided to recognize Western Sahara as part of Morocco. And this territory, Western Sahara, as you may know, is a colony. It belonged to Spain, and until now, its status was still pending. It was under. It is partly occupied by Morocco, but the UN has included the Western Sahara as a territory which its self-determination has to be decided. But what happened with this case? President Trump deciding to recognize Western Sahara as a part of Morocco, and that conditioned the Spanish policy. Spain had maintained until now a very strict approach to this topic. They wanted the Western Sahara to become an independent state, or at least to exercise the right of self-determination without interference of Morocco. But a year and a half ago, the Spanish government decided to follow up on the US, and basically they surrendered their position. And from the Spanish perspective, at least from the Spanish perspective, Western Sahara can be considered as a part of Morocco. So this is a big concession that Spain has done, again, following what the US initially did, but without pondering, first, the legality of the measure, and second, what are the legal consequences of that measure for Spain and for Europe, because it has consequences both for Spain and for Europe. Again, this is an example, a very recent example. If you may recall, Vice President J.D. Vance, Vice President of the US, went on a trip to Germany and to Europe, and in that trip, he had a conference in which promoted the right-wing party, the German right-wing party, and to which extent this intervention can be considered as getting into the internal affairs of Germany. There were elections in Germany in a few weeks, and the US Vice President basically did some campaign for the right-wing party. This shouldn't happen. This shouldn't happen. But as you see, sometimes these situations take place and they have consequences. The elections took place. The right-wing party had tremendous results, and of course, this could have future consequences for Germany and for Europe. And this is a clear intrusion from the US in the domestic affairs of Germany, and I would say in the domestic affairs of Europe. But this situation, apart from the consequences for Germany, of course, will have consequences with regards the relations between the US and the European Union vis-à-vis the situation in Ukraine. So, complex relationships in 2023, just within the Biden administration, both regions try to reach an agreement in principle, try to settle their disputes, try to reach agreements regarding several issues. And it's quite interesting to read a joint declaration that both regions made on that date, 20 October 2023, because if we read what they said then and we see what is happening now, you'll see that international relations can change dramatically. I have some paragraphs that are worth reading. Look, for example, regarding the relationships between the US and the European Union. Well, at least if you read this, there is a clear commitment from both parties for multilateralism. Work together. There are several areas in which both parties could work, and look at this, including in our steadfast support for Ukraine. A year ago, 1.5 years ago, both parties agreed that they were going to support Ukraine. Well, things have changed. Both parties then were promoting multilateralism. Now, well, if we talk about the situation in the Middle East, things have also changed. This is what they say then. Look, this is about the war in Ukraine. We are committed to supporting Ukraine for as long as it takes to defend its sovereignty and territorial integrity. Things can change in international relationships. A change of government can have consequences. Russia must cease its aggression and must bear the legal consequences of all its international wrongful acts, including compensation for the damage caused to Ukraine. Now it seems that it is Ukraine that has to compensate the US, Russia, and everybody for the war. So as you see, the scenario has changed dramatically in the last 1.5 years. I don't want to bother you with the commitments or the statements made with regards other parts of the world. I think that it is quite interesting to see what the commitments were regarding Ukraine. For instance, look at this cooperation, defense cooperation. At that moment, there was a clear commitment of using NATO as a tool to base the collective defense. Now, that statement could be subject to some amendments from the US part. So the situation, as I said, has changed. We have, from the trade perspective, we have initiated a trade war against the US, or let's say correctly, the US has initiated a trade war against the rest of the world, and we are part of that trade war, and we will suffer its effects, and of course the US and its citizens will also suffer the effects of that trade war. But of course, this trade war has also consequences for the political perspective in Europe. It is not only that there are measures, trade measures against products originating from Europe. There is also the support of the current US administration to several political parties, right-wing political parties, and that could also have, in the medium term, could have influence and consequences in Europe. So we must see this trade war also from the political perspective. What are the consequences of this, the economic consequences of this trade war, and also the political consequences of this situation? And it is quite paradoxical that we are talking about a trade war, because at the end of the day, the US and Europe, we share values. I think if we sit down and reflect what are the bases, the values that both societies share, I think that we could affirm that the rule of law, human rights, and democracy are at the top, both there and here. So it is quite paradoxical that we are in this situation, but at the same time, we share values. So can we establish a trade, an investment, a political relationship with someone with which we trade values? Of course, it's easier. It would be easier to establish a permanent relation with a partner with which we share values than with a partner with we do not share values. For instance, would it be easier to settle a trade relationship with China or with Russia now? Do we share values with them? It seems a little bit contradictory. We are in the short term involved in a trade war with a territory, with a region with which we share values. But this is how international relations work, and sometimes these situations really are a little bit contradictory. And in the long term, in the medium long term, we'll see how they evolve, because of course they can evolve and they can change. Look, for instance, this map shows you the importance of China in America. In 10 years, there are a lot of countries, Latin American countries, that are no longer under the influence, under the economic influence of the US. China has become the major trade partner of those countries. And of course, these could, to a certain extent, could explain why the US is taking such measures, such drastic measures against Europe, and also, of course, against China. they're worried. This was its natural market regarding trade, and it seems that it no longer is. That there are other states that are benefiting from it. For instance, it is not only Russia. Sorry, it's not only China. Look at Russia. It has some influence in certain countries, Latin American countries. So the US has reasons to be worried about this situation, but of course, Europe has nothing to do with this. This is Russia and China. So in any case, what the US should do would be to cooperate with the European Union to promote trade based on the WTO principles and regulations with the European Union and the Latin American countries. But as you see, they seem concerned about the rise of the influence of Russia and China in Latin America, and that concern has created a lot of decision making, which is not consistent with the logic at some point. So, bottom line, the European Union, from its conception, established a multilateral system based on free trade, no tariffs, etc. The US also followed that path, joining the WTO, but now, in this moment, currently, the current position of the US government is unilateralism, to avoid any resource to institutions and to settle the relations among states on a bilateral basis, or I would say unilateral basis, because at the end of the day, as we saw in Washington a few days ago, when someone meets with President Trump, it's not a bilateral discussion. It's a unilateral discussion, unfortunately. So this is a change of paradigm, and we must be aware of this. The European Union should continue to promote multilateralism throughout the world. I think it's an objective that has to be promoted and achieved. And the US, let's see how things evolved. To a certain extent, maybe it could change in the future, but now they are avoiding multilateralism, and they are negotiating on a unilateral basis with states. That means that they do not support the institutional framework that has been created by the UN or another international organization. They will try to avoid the settlement of disputes throughout international organizations. They will prefer to settle disputes on a bilateral or unilateral basis. So that's what's happening with regards to trade, and that situation is leading to the trade war that we were talking about. So this is the first part of my presentation regarding trade, and now I would like to devote some minutes. I think that I still have some minutes to talk about investment. Yes, I don't know how many minutes.
15.
Okay, so I think that I can give you some ideas regarding.
If you make it less, we'll leave 5 minutes for questions, but it's up to you. Okay.
Okay. No, perfect. So I have some thoughts on investment. I already mentioned that there was during this few years there was some sort of negotiations between the US and the European Union in order to reach to conclude a trade and investment agreement. and which ended without success. Now the question is, can the US and Europe conclude this agreement? Of course, the answer to this question is no. At this moment, it is not possible to conclude the agreement. Let's see what happens when governments change in the future. Maybe there is another opportunity there, but at this moment, there is no possibilities of concluding that agreement. Would it be necessary to conclude that agreement? Well, that agreement, we have the general framework of the WTO, but if you recall, the European Union has been very keen in negotiating specific trade and investment agreement with all the majority of states. So from the EU perspective, I think it's important to conclude that agreement, but of course, not at all price. It has to be a balanced agreement, and of course, it has to be an agreement with settles certain issues, investment issues with the US that are currently unsettled, and this will take time. This is the agreement that we were talking about, the Transatlantic Trade and Investment Partnership. It wasn't a success, but at least we have some background for the future. We have 15 negotiating rounds and all the documents that were produced during those 15 negotiating rounds, and I think those documents could be used in the future in order to build some momentum and to negotiate a future agreement. Although once that moment arrives, politicians in Europe will have to explain to civil society the content of the agreement, because, as I said, part of the European society did not support this agreement in principle. So once these negotiations are resumed, it is a responsibility of our politicians in Europe to explain to civil society what are the benefits of this agreement. And this is something that sometimes our politicians take for granted, and they shouldn't. They should explain. Of course, they cannot enter into details, into the legal details of the agreement, but they should explain what are the pros and cons of any international agreement that the EU is negotiating with a third party. The society has the right to know what are the commitments that the EU and its member states are taking vis-a-vis another state, and more importantly, which are the consequences of those commitments for the citizens. Why this agreement was objected by parts of civil society a few years ago? Well, of course, there were a lot of reasons, but one of the main reasons of objection was investment arbitration. The agreement included a dispute settlement mechanism for investors, for investment-related disputes, that part of civil society thought it was contrary to the interests of the European states. Maybe you have already heard about the investment arbitration and what are the consequences of investment arbitration, but this agreement included, or better said, allowed foreign investors or investors from the US to bring claims against the European Union before international tribunals, whereas the moment, since there is no agreement, if a US investor has a claim as a result of a measure taken against it, the US investor has to resort to the domestic courts of the EU member states. With the agreement, the domestic courts no longer work. In this situation, the investor has the right to bring an international claim against the EU or the member state. And parts of civil society thought that by granting that power to US investors, a lot of cases would be brought against the European Union, and of course, these international tribunals would rule against the EU, and the EU would have to pay compensation to US investors. So this is basically at the basis of one of the major criticisms that civil society raised when the agreement was negotiated. This is an example of investment arbitration in Italy, and not with regards to a US investor. This is a UK investor that, as you may know, this is one of the most important cases against Italy. It's related to oil exploration and exploitation, but it's quite illustrative of the legal consequences of investment arbitration. In this case, a British corporation initiated an investment claim against Italy because the Italian government decided to block the concession of oil exploration that had been previously been granted to the corporation. And of course, the corporation thought that by blocking by suspending that authorization, Italy had to pay compensation to the company, and the tribunal found for the company, and it is quite I think that the award establishes around 150 million euros, around that amount of money that Italy has to pay to the corporation. So as you see, it has important economic consequences for states. What civil society thought was that by granting US investors this possibility, a lot of cases will be brought by US investors. As you may know, US litigation is part of the US culture, so they are very, very happy to litigate wherever they operate. And of course, there are consequences there can be consequences, economic consequences for the European Union and its member states. So, is this a good argument? Can we argue that we must oppose an international agreement with the US because the agreement allows this possibility for US investors? Well, this possibility is granted on, and this is very important, this possibility is granted on the basis of reciprocity. That means that the same applies to any EU investor having a problem in the US. They could all resort to investment arbitration. So, in my opinion, it is a cause of concern. And it is very important that civil society took notice of this, and they raised concerns. But I wouldn't say that is the existence of investment arbitration has to be the reason for not concluding an international agreement with the US. Of course, if the agreement provides for investment arbitration, there will be cases against EU member states. The US investors will use this system, but I mean, the European investors could also use the system. So it is a cause of concern, but it is not a reason not to move forward with the negotiation of the agreement. Anyhow, it is important that this issue was raised during the negotiations of the agreement, because Italy has negotiated a lot of bilateral investment agreements providing with investment arbitration, and I haven't seen Italian citizens protesting against the negotiation of those agreements. Spain has negotiated a lot of investment agreements with third countries, and I haven't seen Spanish citizens protesting against the possible consequences of investment arbitration against Spain. So at least this issue at EU level allowed for a debate on whether this system of dispute settlement is balanced, and also allowed for the EU to promote certain reforms to the investment arbitration system currently in place. But I think that if I enter into the explanation of the reforms, I may run out of time. So maybe, Leonardo, I don't know if we open for questions now, because if I start with this, maybe I run out of time and we have no time for questions. Yeah, it's up to you. You decide.
I agree. Let's stop here. Thank you very much, Francesco. So much, Francisco, for your excellent and illuminating class, as usual. So if you agree, I will open the Q&A session right now. Allora, se qualcuno vuole fare domande, le possiamo fare in inglese, ma anche in italiano, tanto Francisco capisce, non parla, ma capisce, poi in spagnolo ovviamente anche. Quindi se qualcuno vuole fare qualche domanda, abbiamo pochi minuti. Su temi molto attuali, molto trattati, temi molto, insomma, molto importanti. Sì? Sì, perché non si sente, non c'è diversa.
Devo parlare qua.
Sì, comunicare.
Do you think that the only solution to what is going on with Trump's administration is to wait it out? Or does the EU have the regulatory power to counter the threat of the tariffs?
Avete capito la domanda? La per ripetere in italiano per i suoi colleghi?
L'unica soluzione che finiscano queste minacce di tariffe è attendere la fine dell'amministrazione di Trump, o l'Unione Europea ha il potere regolatorio di combattere queste minacce?
Well, these measures that I think it's a very interesting question, because it allows us to refer to some general concepts of international law. These measures that were taken by the Trump administrations are not consistent with the WTO system. So since we could argue that they are not legal, the states that are the recipients of the measures could adopt countermeasures against those measures. Of course, they have two legal avenues. First, to adopt countermeasures, which is, I think, the most imminent avenue. And there is another option, which is to initiate a dispute settlement procedure against the US within the WTO. But if we choose this second legal avenue, we know the outcome. Since there is a paralysis of the WTO dispute settlement mechanism, the European Union could win the case, but maybe the US would raise an appeal, And since there is no appeal mechanism, the case, or in this case, the measures would be still implemented by the US. So I think that what the EU did by adopting countermeasures against trade countermeasures against the US is the proper reaction in this situation. Of course, when you adopt countermeasures, those countermeasures need to be proportional. This is one of the conditions of countermeasures. Proportional, and when the state that has adopted initially the measures decides to withdraw them, then the EU would have to withdraw its trade measures. So the EU has at this moment ways to react to the measures implemented by the Trump administration. It has to do it, it can do it, and it has to do it. And I think that the way that the EU authorities decided to go by adopting countermeasures is the best way possible. But again, these measures have to be proportional, need to be proportional in order to be effective and legal in accordance with the WTO system.
Allora, rapidamente, non so se avete capito tutti la risposta. Dice, dal punto di vista legale ci sono due opzioni. Siccome il comportamento degli Stati Uniti è illegale, alla luce del diritto internazionale, ci sono delle due opzioni teoriche. Una, adottare contromisure, è quello che l'Europa ha fatto, e un altro, ricorrere all'Organizzazione Mondiale del Commercio. Però l'Organizzazione Mondiale del Commercio, il sistema di soluzione delle controversie, è di fatto bloccato, come ci ha spiegato durante la lezione il professor Pascual Vives, perché c'è il problema che non sono stati nominati giudici d'appello, d'accordo? Quindi l'unica opzione è quella che effettivamente ha intrapreso l'Unione, cioè quella di adottare contromisure, che però naturalmente alla luce del diritto internazionale devono essere proporzionate. Ok, abbiamo forse tempo per un'ultimissima domanda, se qualcuno la vuole fare, se no ci salutiamo perché l'ora praticamente è finita. Posto così, grazie a tutti di nuovo.
Thank you very much.
Ya está.
Thank you, Leonardo. Gracias.